I would love to say it did, but don't think so, because I don't have any, now that's a problem if you're doing it abstractly, I don't have any indication that what that enacting Congress did was trying to do something which was relational, or was giving authority, delegating authority to an administrative agency to update. And given that, I think it is too dangerous to let loose, because I just don't have enough to guide me on it. On the other hand, if I could find some indications that the mischief was such that at the time they passed, they were thinking in terms of an agency that would have the authority to deal with this law in the delegation to the agency or in something else, then I might do something. But without more, I start with the words, and it is not clear enough for me to say that that could be done. Now, that makes me unhappy, because I think that is not a good result, but it's not an absurd result, and it is more plausible to me to say the legislature there put the inertia in one direction, and if they don't like it, they can do something about it. Now, is that conservative, by the way? I'm not sure.
I'm smiling.
I'm not sure that will be anything.
Judge Easterbrook?
And if he's expecting me to say anything different, no, not a chance. The difference between Judge Calabresi and me on this is that I don't regret it, even remotely. And I'm not looking for a way around it. And the reason for that is that the statute, as John Manning proposed this hypothetical, has a particular kind of structure. It sets out a rule. It's not a delegating statute. It's a statute designed to tie the hands of the agency. And legislatures often tie the hands of agencies when they don't trust the agency. And it may be that there's an argument for untying hands, but that has to come about by legislation. All of you may remember that there was in force for something like 50 years a statute that said the Federal Food and Drug Administration cannot approve any food additive that's known to be a carcinogen. And after that statute was passed, the adoption of mega mouse studies made it possible to find carcinogenic effects in the kinds of substances that earlier no one would ever have suspected was a carcinogen.
Just sitting on a panel was a carcinogen.
Could be. So the upshot of the law was that almost no food additives can come to market, but there was also a grandfather clause, so all old food additives stayed on the market, so that things that were safer could not displace the older and less safe things. The question arose whether the agency could just ignore this statute now that everybody agreed it was counterproductive. And the answer given by the D.C. Circuit, I think entirely correctly, was no. It was a statute, the goal of which was to prevent the agency from exercising discretion. And as soon as the D.C. Circuit handed down that opinion, Congress amended the statute.
Now, when I say with regret, what I'm saying is we want to think about whether we want to urge Congress, when it is enacting statutes of this sort, in situations where scientific things are apt to change in dramatic ways, to give courts power to construe. That is, Frank has said they can do it, and in antitrust, ERISA, and so on, they have done it. In my book, I suggested that it might well be that there are broad areas where legislatures would be well advised to have courts act like common law courts, even though there are statutes, because the results would be better from a study of the starting point. And in that, I suggest different situations where that might, not will, make sense. And I suggest that one of the dangers of not doing that is the tendency for courts to lie about interpretation and say something meant something else. And a much more dramatic danger is for courts to use the Constitution to strike down statutes that they think are absurd, which is much worse because it doesn't allow the legislature then to come back and say you were wrong, as the California courts did with the guest statutes, which isn't so bad in California because a referendum can then change the California Constitution. But the moment California courts do it, Washington state follows, and Washington Constitution isn't so easily amended. So there are situations where it may be wise to give courts the power, and I don't know whether in this kind of thing, giving courts giving administrative agencies the power to do something reviewed by courts may not be a better statute. But I don't think they did it here. And since it is equally plausible to me that they were trying to restrict the agency, I'm not prepared to say that they did it.
Yeah, I certainly agree with Judge Calabresi that you can imagine circumstances under which giving courts discretion lead to better outcomes. I am, after all, from the University of Chicago, which is associated with the idea that judges tend to produce efficient decisions compared to legislatures, which tend to produce rent-seeking decisions. And I think there's a good deal of evidence that common law beats statutes on efficiency grounds. But one has to be very careful of this, and not just for the reasons Doug Ginsburg gave last night in talking about the unitary executive and the non-delegation doctrine. I mean, you can certainly undermine the ability of an executive to operate by transferring too much authority to courts, as well as by transferring it to the agencies. But it's also the case that it becomes very difficult to figure out when you have gone wrong. And having just praised the D.C. Circuit for its decision in the FDA case, I also have to remind you that the reason why we have so many coal-fired plants and so few nuclear plants, even though on almost any estimate, nuclear plants are much safer and have obviously a much smaller carbon footprint than coal plants, is because the D.C. Circuit, engaged in review under the Administrative Procedure Act, resolutely blocked the development of nuclear power in this country by choosing to find ambiguities in the Act and eternally remanding cases to the Nuclear Regulatory Commission until A, they could never get a license through anymore, and B, every plant had to be retrofitted every 6 months with new and more expensive technologies. My suspicion is when nuclear power comes back, and the current administration is leading the way on that score, it will come back in a way that ties the hands of judges in light of that experience. So it's very difficult to know when a delegation might do more good than harm.
Two things on this. First, let me say that I thank God I'm a religious person every night, that I'm not on the D.C. Circuit. There are other circuits represented here that I thank God even more for, but I'll leave that to Judge O'Scanlan. That's largely because I think administrative law is such a mess for many of the reasons that Frank has said. I had one objection to what he said, which was it's all right in some situations to give courts discretion. The tendency when power to construe in a common law way is given to courts is to talk as if this is giving courts discretion. Discretion is a different word which means something very different. Discretion allows you just to use your judgment, to do what you want, to do any number of things. It is true that Dick Posner thinks that courts have that power. I didn't think that Frank Easterbrook thought that. I do not.